Hello and welcome to Listen Up Landlords with Ben Beadle and me, Richard Blanco. We have entered a new era. Phase 1 of the Renters' Rights Act 2025 came into force on the 1st of May 2026, and it heralds the biggest change in legislation for the private rented sector in nearly 40 years. Assured periodic tenancies, pet requests, a maximum of 1 month's rent in advance are now all part of the legislative framework. As we bid farewell to Section 21, we make way for revised grounds of eviction under Section 8, which include a 12-month lettings ban if you want to sell or move into the property, and 4 weeks' notice where the tenant is 3 months in arrears, not 2, and you are seeking a mandatory eviction. Change often brings with it anxiety. No-fault eviction was abolished in Scotland in 2017, but some landlords operating there say the new system has not been particularly onerous. Key concerns in England will be getting stuck with a tenant that behaves antisocially or pays rent sporadically, long waits for court hearings, tenants routinely seeking tribunal decisions on rent rises, and savvy operators gaming the system by giving 2 months' notice on day one or signing a tenancy agreement and then not paying any rent. Advocates of the new system say that it rebalances the letting relationship by giving tenants more security of tenure, and it removes hardships inflicted on them like rental bidding wars by the assured short-hold tenancy system. So Ben, is this in any way the beginning of a bright new age or just a new hair shirt that the landlord fraternity has to get used to?
Well, we're used to getting used to new things, that's for sure, Richard. I think a lot of landlords will be approaching the 1st of May with deep caution, to be honest with you, and real uncertainty about some of the next steps. But I hope that after a short period, that landlords will be able to get to grips with the new regime and the new system. And certainly, all of the support that we're putting out should, I hope, put landlords well placed to be able to deal with some of the very difficult things ahead.
Now, you were at the coalface negotiating hard. What are your biggest regrets, if any, Ben, about perhaps what you didn't get that you'd like to have got?
Yeah, I mean, the minister has written in our magazine talking about the robust challenge that the NRLA put to him. But he's a man on a mission. He has a very clear view of the world. That isn't necessarily um, my view of the world or our members' views of the world. But he's the man that makes the decisions. And I think that what I want members to understand is that that challenge and discussion with both him, Steve Reed, and senior civil servants was both intensive and robust, as Matthew describes. But there are some very key concerns that remain, and I'm pleased that Matthew is still continuing to engage with the landlord community because, as I've said to him directly, he needs landlords. He needs these reforms to work, and he needs landlords to continue to provide homes. So some of the concerns that we have, and we're still in the room being able to put these concerns, which obviously, we don't want to throw our toys out the pram and not be in a position where we can't do that. That's not what members expect. But we have grave concerns over court capacity. We have grave concerns over the ability of the first tier tribunal to be able to process claims in a timely fashion. And I think that we have grave concerns over sort of awareness and that sort of transition period on quite how much information has been pumped out to landlords to enable them to get it right. And we'll be certainly holding feet to the fire over these things as the reforms take their passage. But as landlords know, it is incumbent on responsible landlords to get on with it and do it well.
Yes, there have been some wins for the NRLA, haven't there, Ben? Some concessions were made.
Yes, I would characterize them as fairly small beer in the grand scheme of things, but they were concessions nevertheless, whether it's around the notice period and transitional arrangements for student tenancies or a number of other relatively small scale things, but significant in the context of what we're dealing with. And I think that, that there will be members out there and the wider landlord community that say, well, why didn't you get on your tractor and go down to Downing Street Well, I haven't got a tractor, sadly. I quite like a ride on tractor,
We
but
could have hired one, Ben.
we could, yeah, we could have hired one. I don't know whether that would have necessarily advanced the argument, or whether it would have meant that we got even less. It will be for those to determine. But for now, what we're focused on is servicing the near 1,000 calls a day that we're getting from landlords, making sure that our governance and documents and forms are there for people to be able to comply and avoid the fines, and be that supportive player that we aspire to be, as well as making sure that we keep a very close eye on things that are working and things that are not working.
Yes, as you say, it's a moment for pragmatism in many ways, isn't it, Ben? And the NRLA is there by the side of landlords to assist with all the kind of paperwork and understanding the new system that they will need. Well, look, we're going to dedicate this episode to the phase one implementation of the Renters' Rights Act, where many of the major elements come into force from the 1st of May. And we're joined by three guests: Robin Stewart, who's a partner for housing and property disputes at Anstey Gold; Alison Thompson, Chief Lettings Officer for Leaders Romans Group; and James Wood, who is NRLA Head of Policy. Let me bring you in first, Robin. I wanted to ask you about the sort of tail end of Section 21. What issues are coming up around the Section 21 transition in those final cases that might go to court? I've had people asking me lots of questions like, if they issue a Section 21, do they still need to give out the government information sheet on the Renters' Rights Act? Can they issue a Section 21 saying they want the tenant to leave in August or September, even though the final date for going to court is the 31st of July? So those are things that are popping up amongst people I know. I'm curious to hear what else is coming up for you.
Well, Richard, the first issue is going to be the final Section 21 notices which have been served, and whether those will be valid if landlords have to go to court. And so that's going to be a big issue, because obviously there's more incentive than ever for tenants who desperately want to stay to challenge those notices. And so in the past, we find many tenants might suspect that a notice was valid, but choose to move out pragmatically anyway. And we just don't know how many of those tenants will think, I've got a chance to fight this notice, and if I win this time, that's me. I make it into the assured periodic tenancy regime. So that's good news for lawyers, I'm afraid to say, because when people argue, that's how we pay our mortgages. We'll see. I think there's more incentive than ever for tenants to take technical points about gas safety certificates being not served or having defects, and those issues haven't gone away in respect of any of the final Section 21 notices served in the run-up to the 1st of May.
There's that long list of documents that you must have given to the tenant at the start of the tenancy, etc., the government's how to rent leaflet and the electrical safety certificate and so on. I'm curious to find out from you as well, Robin, which possession grounds might be trickiest going through the courts under the new system?
I think there's going to be a lot of arguing about the amended ground one, that's for a landlord who wants to move in or move their family member in, and new ground 1A, which will apply where a landlord intends to sell. These are going to provoke arguments because it's very difficult to prove an intention, and some tenants are going to be very suspicious when they receive a notice relying on those grounds, and they're going to be troubled by the lack of evidence. But how do you prove an intention otherwise than simply by having that intention and saying you do? There'll be some situations where we can rely on supporting evidence, like things the landlord has done to progress a sale, but other times it will be a challenge to prove an intention because there won't be any supporting documents that exist.
That's so interesting to hear, Robin, because a lot of landlords have been kind of relieved that those grounds exist, and they will allow the landlord to get possession if they want to move in or sell the property. But you're saying that actually we could see quite a lot of case law on that. Alison, let me bring you in, because I wanted to ask how the Renters' Rights Act is affecting the market now. What behaviour changes, if anything, have you seen in landlords over the last few months?
Thanks, Richard. Yes. Well, talking of Section 21s, we have definitely seen a spike in Section 21 notices I think we've seen a gradual increase over the last couple of months, but in particular in the last couple of weeks, we've seen circa 35% increase in terms of the number of notices. So I think there's a bit of short-term disruption whilst some landlords are using this opportunity to exit the market perhaps earlier than they would have planned. And I think, so there's some short supply in certain areas. It's going to prove a little bit tricky for some tenants. I think the other thing that's happened is potentially a slightly lower investor appetite coming into the market, but even though rents are still rising, they've slowed down a little bit as well. So I think longer term, we're already starting to see that some of those accidental landlords, maybe the ones with 1 and 2 sort of properties, are starting to make their decisions and perhaps exit the market for varying reasons. But, I think this is a trigger point for them. And then I think over time, we're going to see a more stabilised, perhaps a more predictable market, and a bit more of a professionalised landlord demographic that might help us and tenants to have a better choice, a longer term choice, with some of the landlords that perhaps have or would need to have sold have gone, and then the rest that remain are a bit stickier, if that makes sense.
And Alison, I wonder whether I might just push you a bit further on this. I mean, so appreciate some landlords are exiting the sector, but are you seeing the reverse of it being an opportunity to bring landlords that are concerned about sort of punitive fines and compliance into management?
Yeah, that's a really interesting one, Ben, because I thought this would happen a bit sooner than now. But I think the penny has just started to drop. And we are definitely seeing, as a managing agent, we're definitely seeing some self-managing landlords come to us and ask for some advice, particularly around the administrative burden now, because I think some of the surveys that we have done in LRG over the past few months, or certainly sort of 6 or so months leading up to the 1st of May, some landlords are feeling like there won't be any disruption, but there are other landlords definitely, as this date got closer, we have started to get an increasing amount of landlords move from self-management to fully managed, where perhaps it's more around time, I think. I think that the time, the housekeeping, the documentation, the compliance concerns, where the intent is very much there, but it's just making sure that they don't get caught out by these sort of punitive fines. I think that we'll see that increase even more.
James, I'm interested to find out from you what you think about the 12-month letting ban, because, a lot of landlords are going to be selling up, presumably, if they've issued those Section 21s, because they're kind of wanting to avoid that 12-month letting ban that will come in under the new system. But of course, that could lead to quite a lot of empty properties in a housing crisis if buyers fall through. And that's not a good look for the government, is it? How do you think that could pan out?
Well, it's not, and hopefully it's not going to come out in great numbers. But if ultimately there are loads and loads of properties just sitting vacant because landlords are selling up, then obviously that's going to cause quite serious issues in certain areas. And if we look at the experience in Scotland, a lot of the possession cases that go on through the Scottish system are actually sales. I think when we looked at it, it was around about 50% of all of the possession claims made in Scotland during the period of the rent controls was actually related to sales. So if you applied that same rule in England, you would find that half of all possession claims are suddenly also coming along with a ban on reletting the property for 12 months afterwards. So yeah, you probably are looking at least 6 months minimum, even where you're rapidly selling the property. But it's a big problem going forward.
Alison touched on landlords changing their habits, maybe moving to a managed service. You've been at the forefront of making sure NRLA documents, forms, and advice is absolutely on the money in terms of quality. What are you hearing? What do you think landlords are most concerned about with these changes?
It's an interesting one because the Renters' Rights Act is such a big and all-encompassing change, and there are so many new duties that I think the concern changes depending on what your market is, really. If you're a student landlord, it's the loss of fixed terms that's giving you the most concern at night. If you're a larger portfolio landlord, it's probably the changes to rent increases, because you can no longer plan out effectively when your rent increases are going to take effect. But then you've also got that group of landlords who let to the general market, who really aren't affected by too many of these changes at all, and their biggest concern is making sure that they don't get one of those bad tenants that they might not be able to evict in a timely fashion anymore, where something goes wrong. And so for them, it's going to be about making sure the referencing is right, and they've done everything they can to avoid that kind of scenario coming up. But really, it's going to depend on who you're letting to and what your market is.
And just to take that a step further in terms of a specific market, then, obviously, if you're a student landlord, there's going to be even more trepidation about whether a tenancy is going to come to a natural end and when you're going to be able to re-let it. But obviously, we've also got a 29% loss of housing in the student sector, with 1- and 2-bedroom properties sort of falling outside of the provisions. What's your best assessment of what will happen there?
I think it's going to negatively impact on students. We've seen this scenario play out in Scotland, what many student landlords did, and also many landlords who let to higher risk tenants, was to move into the general market. It was to move into letting to more stable tenants with better employment prospects, better affordability. So the end result of it was my old university, Glasgow, was telling people not to come because they couldn't find houses for them. And I really hope that scenario doesn't play out in England as well. But that's the experience in Scotland, and I think it's entirely possible it plays out in England as well.
Indeed. Robin, if I might turn to you, Alison mentioned about a sort of a spike in Section 21s in these past couple of months or so. Are you seeing more cases going to court right now? And do you have confidence in this perennial fallback on digitalisation as being the cure to all of our court woes?
Well, yes, it's a big government IT project, and I think we all know what that might mean. My experience is probably a bit anecdotal to mean too much, but in the last year or so, I've certainly seen an uptick in landlords serving a lot of Section 21 notices, those saying they're moving out of the sector. And then there's been another rush in the last few weeks of many people realizing that this is their last chance. And then the rush on taking cases to court is going to come in the weeks when those notices expire in the run up to the 31st of July, which is the hard deadline. So I'm expecting to get a lot of panicked phone calls in late July asking me to put together some court papers very rapidly. We know a little bit about what's going to happen with the courts because there are procedure rules being written for an online procedure for possession proceedings. And so we know that's coming. And I think it will help a bit. And it's a sensible thing which needs to happen. A colleague was in court a couple of weeks ago with a case which had settled. The landlord and tenant had agreed what was going to happen, but the judge didn't have the physical file and refused to deal with the case. So that's the kind of crazy thing that shouldn't happen anymore with a modern court system using digital files. But it's not going to solve the big problems about there simply being not enough judges and not enough court space. So yes, I think it'll help, but it's simply not in itself a solution to the big problems.
Robin, what pitfalls do you think there might be around the rental bidding ban and this bidding wars issue and the idea of fixed rental prices?
I certainly don't know what's going to happen with this, because it seems obvious to me that at first landlords might think to themselves, let's just post a really high asking price and see what offers I get, but that's not attractive either. So that will have to balance itself out, and I'm watching that with interest. But then following on from that, there's two issues I'm particularly concerned about. One is what's going to happen when a landlord advertises a property and realizes quickly that actually they've underestimated the market and they should have asked for more rent. They're going to want to take the property off the market, rethink and put it back on again. And clearly that's going to look very suspicious. It's not going to be a great look, but I find it difficult to accept that you can't do that. You must be allowed to change your mind, rethink your letting strategy, and put it back on the market. So that's one issue. And then the second is, if we've got a market which is operating in such a way that the landlord is stuck with the rent that they've advertised as the asking price, it's just going to make the temptation even worse for people to fall victim to rent scams. Because if people are approaching that landlord and saying, you can only attract this much rent from a regular tenant, but I can offer you something extra, the temptation to go with that and not ask the difficult questions from that rent provider might be too much for some landlords.
This is Listen Up Landlords, and you're listening to a special edition dedicated to the Phase 1 implementation of the Renters' Rights Act with our guests Robin Stewart, who's a partner at Anthony Gold, Alison Thompson, Chief Lettings Officer from Leaders Romans Group, and James Wood, NRLA Head of Policy. Robin, just a quick follow-up actually on HMOs and children, because of course landlords won't be able to discriminate against families with children, etc. So will HMO bedsit landlords be expected to accept children?
This is an area where there's some good news for landlords, I think, because the ban on discrimination against letting to people with children and families isn't an absolute hard prohibition. It is possible to take it into account that a prospective tenant has children, and where it's simply not going to be suitable to let a particular property to someone with children, it's lawful to take that into account. So the way it's expressed in the Act is if it's a proportionate means of achieving a legitimate aim, that's not unlawful discrimination. And then if you go and look in the government guidance, it gives a couple of examples of things which are not unlawful discrimination. One is in a student bedsit HMO, it's suggested that it would be completely fine to make the decision that it's not appropriate for a child to be living at that property. And the other example relates to a licensed HMO, where it simply wouldn't be possible to comply with the license conditions to do with children having access to private cooking facilities. If it's not going to be possible to comply with the license conditions in your property, if there's children, that's a legitimate reason to say, I'm sorry, I can't let to anyone with children.
Okay, well, some reassuring common sense there from this piece of legislation. Alison, I'm interested in how the legislation might make us change the way we manage tenancies. First of all, tenants will be able to give 2 months' notice at any time. And how do you think this is going to affect planning for tenant changeovers? I've always preferred to give people 1-year contracts because it means, we know when the end's coming up, we can discuss whether they want to renew, etc. It seems to me I'm suddenly going to find tenants moving out at a time when I was doing my 1-month trip to Australia and hoping to kind of not be in the country. Do you think this is going to be a big change for landlords, or are we just going to all take it in our stride?
Look, I think tenants' behaviour initially, I don't think will change. It costs a lot of money to move house. So because you've got the opportunity to give 2 months' notice and move fairly quickly into what would have been a longer fixed term, doesn't necessarily mean they're going to, because moving house is a lot of money. So I don't foresee a significant uptick in tenant behaviour, but I definitely think with changeovers that does present a little bit of cause for thought and to manage it in a way. And certainly my view is planning for changeovers. I think if you've got, say, for example, 3 tenants in a property, one chooses to leave, but the other 2 choose to remain, then I think everything remains the same, nothing changes. I think if one leaves and brings a new one in, it basically starts as a new tenancy, and the clock starts ticking again. So there's different ways of viewing it. But my sense is that certainly as an agent, what I would be really advocating is the importance of obviously vetting your tenants really well up front. And I think where we've always had a situation where we've been looking at affordability and other criteria to make sure a tenant passes muster to be able to get access to that property. I think the new currency is time. And I think really vetting a tenant to understand the motivators behind the reasons why they want to move into that property, that area, etc., is now more important than ever before, just to see if you can make sure that you set up a tenancy in the best way possible.
Yes, I was going to bring that up actually, Alison, and you sort of answered my question really. The role of vetting is going to be so important going forward, isn't it? And that's where agents can be really helpful. I'm just wondering what's going to happen around renewal fees, because that's quite an important part of the business model, of course, for some agents, Alison. How will the loss of that affect some agents' business model?
Well, look, we've been here before, haven't we, with the tenant fee ban? So we're used to, ducking and diving a little bit. So my view is that every agent, every business will have a different fee structure, a different business model, different operating costs. So you have to look at your business on a case-by-case basis. But my view is that just because a renewal has disappeared, we still want to proactively support landlords to help schedule that annual rent increase. And that annual rent increase has now got certain parameters around it. You can only increase the rent via a Section 13 notice. And also, in order to avoid first-tier tribunal cases, you need to make sure that you've got market comparables to justify the increase that is being proposed. So therefore, I think there's a significant justification in charging a fee to a landlord to negotiate and provide the relevant documentation to increase that rent. So I would say that whilst renewal fees are a thing of the past, rent review fees, other names are available, rent review fees can be considered justifiable in order to make sure that that rent increase sticks, and you do it via the appropriate legal documentation.
Well, with Section 13 in mind, I wonder whether, Robin, you've got a view about the concerns that we have, that there may well be an immediate deluge and rush to the first-tier tribunal to challenge any rent increase that's coming a tenant's way. How do you think it will play out?
I think it's inevitable that there's going to be a deluge, because if you think about it from a tenant's point of view, there's an enormous incentive to challenge every rent increase, if nothing else, just to slow things down. And I think the tribunal does realise this. They've been doing things to get ready. Last year, I went to hear the president of the first-tier tribunal property chamber speak, and she reeled off the official statistics about how many cases they projected to have. But there was a look in her eye which suggested that she didn't really believe those figures and thought it might be much worse. So anything might happen. There are signs that they're getting ready. They've set up new systems. They're getting ready to run those cases through an online portal. But my guess is they're likely to be overwhelmed. It feels inevitable.
And I mean, I'm going off script here, but I dialed into one of the recruitment campaigns that they have going at the moment. And Siobhan McGrath, the president of the property chamber, made it very clear that she expects her workload to triple over the next 3 years. Is it unfair to say there might be a disconnect between what the president feels will happen operationally and what ministers feel will happen in practice? And is that why Penny Cook is maybe giving himself a little bit of wiggle room in the regulations?
I think that's right, because Siobhan McGrath is a very experienced housing lawyer. That's what she did before she became a judge. And she understands that these cases are not as simple as they look. The minute tenants start to complain about property conditions and complain about repairs or lack of repairs in the context of a rent increase case, it suddenly becomes very complicated. It's not just a matter of looking at what other properties in that area are attracting, but it has to involve an assessment of that particular property. And I just can't see any way for a tribunal judge to do that quickly. It takes time.
Indeed, it does. Well, I do think that will be one of the very interesting areas that will be under constant review, not least because rent increases will only apply from the date of the hearing rather than the expiry of the notice. And in there is an inherent unfairness, I think. But anyway, I shall leave my carping, as I said I would at the top of the show. James, I wonder whether I might bring you in here. And obviously the first tier tribunal has a role in enforcement, but so do our good friends at the local authorities. Now, they've been given extra funding to do work. How confident are you that they, A, know what they're doing, and B, are really aware of the challenges that are ahead?
I think it's going to depend on your postcode, to put it bluntly. We know there are local authorities who are excellent enforcing the existing rules and also engaging with landlords. I think Leeds tends to be the gold standard on this. They enforce a lot, but they also have very good relationships with their good landlords. But we've been tracking the data on the use of civil penalties, criminal offences, and so on for years now at this point. And it's fair to say that the majority of local authorities don't do that much enforcement work, or where they do it, they're very specialised into a specific area, quite often a paperwork administrative kind of offence rather than tackling property standards. And so I think a lot of local authorities aren't going to be particularly well prepared for all of this. I know the government's trying to give additional funding and training, and they're going to be required to report annually on what they do. But there are going to be some local authorities who are very good, some local authorities who are very poor enforcing it. And I think there's going to be a lot of them who fall back on the very easy to prove admin breaches rather than tackling what I think are the really important offences in the Renters' Rights Act, which are things like on-the-spot fines for you having a hazardous property. That I think is, I think that's not going to get used anywhere near the level that I think it probably should do. But I think they'll be chasing you a lot for maybe giving out the wrong type of tenancy agreement, or when you start a tenancy. So we'll have to see how it plays out, but I suspect it's going to depend a lot on where you live and a lot on how many EHOs or environmental health officers they have in their teams.
Far from ideal. Robin, I wonder whether we might just give a last word to you. We were very sad at NRLA to learn of the passing of Giles Peaker, one of your colleagues and highly influential housing lawyer. We had the great privilege of working with him, sparring with him on a number of occasions, and my predecessor organisations worked with him on right to rent. It's a desperately sad state of affairs.
It is, and we'll miss him enormously. We'll miss him as a friend and colleague, but the housing law sector and the letting sector is going to miss him, going to miss his blog. But as you said, he was best known as a tenant lawyer, but he did a lot for leaseholders as well. And he led a coalition of people from different backgrounds opposed to the right to rent scheme, a legal challenge which nearly came off, but not quite. So yeah, we're all going to miss him enormously.
Likewise. Well, we passed on our condolences, but wanted to absolutely remember the sterling work that he did for our wonderful housing sector. That's it for this edition of Listen Up Landlords. Do visit the very comprehensive Renters' Rights Hub on the NRLA website for more information.
Many thanks to our guests for joining us today, to Sally Walmsley, our producer, and to you for listening.